So in August of 2009, I married my husband on a farm in Connecticut. And it was a federal judge for whom I clerked who conducted the ceremony. Shortly before he conducted the ceremony, he sat me and Ron down to have a conversation with us. And he said, "You are the first same-sex couple I've married. I only married my former clerk, so it's a small set." But he said, "I have a problem because every time I've married an opposite-sex couple, I have said, by the power vested in me by the state of Connecticut and the United States of America, I now pronounce you married. But," he said, "in your case, I'm not sure if I can say the last part of that sentence because the Federal Defense of Marriage Act says that the federal government does not recognize same-sex marriages for any purpose. So while I can marry you under Connecticut law, I cannot marry you under federal law." This is what Justice Ginsburg would later on call a skim milk marriage because he could only marry us half of the way. But mark the sequel. He said, "I just cannot find it in my heart to do this. So I've slept on this, I've prayed on this, I've talked to my wife about this, and I've realized that I cannot change the words simply because you're a same-sex couple, because this is a marriage. So I'm going to say exactly the same words, and we are going to have exactly the same ceremony as I would have for an opposite-sex couple. And if they come after me, which they may well, then I will say that everything that I do is under the power vested in me by the United States. Because as a federal judge, when I brush my teeth or go to the bathroom, it is by the power vested in me by the United States of America." And I'll never forget my gratitude for his courage in doing that, and that is indeed how the marriage went. While this marriage ceremony is going on the other side of the country, monumental drama was unfolding, where a challenge to Proposition 8, California's ban on same-sex marriage, was being litigated. And for the first time in the nation's history, a trial was held over the course of 12 days on the issue of whether or not same-sex couples had the constitutional right to marry. There had been other state trials, there had been hearings, there had been legislative debates, but this was the first and most fulsome federal trial on the issue. I had, I must admit, a rather ambivalent relationship to this trial because I sided more with the movement lawyers like the ACLU and Lambda Legal and wanting to bring a more cautious, incremental, brick-by-brick, state-by-state strategy. And the individuals who were bringing this case, David Boies and Ted Olson, who had argued the opposite sides of Bush versus Gore, but who had united in this case to be plaintiffs, in the case, to show that same-sex marriage and the right to marry was a nonpartisan issue, jumped the movement lawyer strategy and said that they were going to do this right now. So I kept my distance. I didn't openly criticize the case, but I kept my distance from it until 2010, when the district court's ruling came down. And I read it with enormous excitement because it spanned 136 pages, and it had 80 findings of fact, and it came down resoundingly in favor of the right of same-sex couples to marry. So I immediately sent my librarian off to get a transcript of the trial because it sounded like something very unusual had gone on in this tiny courtroom in California. And she lugged up, God bless her, 13 volumes of trial transcripts spanning 3,000 pages. And I flipped open the first day of the trial. And I had the experience that many readers have. Perhaps it's the experience that defines us as readers, of falling into that transcript and not emerging into everyday life until I turned the last page. So what was it, you might ask, that was so extraordinary about this trial? I want to focus on 5 things. So the first was that it was rigorous. As I know, to my chagrin, if you go out on cable news or if you testify in a legislative hearing, on same-sex marriage, you don't get much time. And your party opposite can, if they're a smart person, which most of these people are, run out the clock or pivot away from the question so that it's never answered. Don't try this if you're a deponent or a witness in a federal trial, because you'll be deposed before the trial for up to 7 hours, and then there'll be a voir dire, which is a questioning of your credentials to take the stand in the first place. And then you can be cross-examined on the stand for open-ended periods of time when you're under oath and you have no lifelines. So the rigor of this trial was extraordinary, that individuals literally took the stand for a day and a half to defend their positions, whether for or against same-sex marriage. Second, the trial was comprehensive. It hit every single possible issue legally about whether gay people should have the right to marry or not. So the questions implicated were things like, what is the right to marry? What is the history of marriage in this country, and what does it mean to have a civil right to marry? It also included things like, what does it mean for gay people to be a protected class? Are gay people more like racial minorities, or are they more like, say, polygamists, who are not considered to be a protected class? And to engage in that inquiry, we had to answer questions like, have gays suffered a history of discrimination? Are gays politically powerless? Is sexual orientation immutable? Do gay people have an equal capacity to contribute to society? And then finally, what are the purposes behind these bans on same-sex marriage? So do gay couples actually do a poorer job of raising children than straight couples? Are straight couples, this is my favorite, engaged in such rickety relationships that could lead to reckless procreation, such that marriage is needed to keep them in check and bound to each other legally? Right? These questions were all thoroughly vetted across this 12-day trial. Right? Third, civility. One of the things that may strike you as odd is that I'm touting the virtues of civility when we're talking about an adversarial process. And it may be a sad commentary on the state of our politics today. But the trial was experienced by all who touched it as an oasis of civility. Opposing counsel Ted Olson and Chuck Cooper embraced each other before they began oral arguments every day in order to show that even though they were on opposing sides of the issue, they could nonetheless remain on friendly terms. And many of the witnesses who had initially balked at participating in the trial when told it was some vague thing to restore marriage equality in California said that they were willing to participate when they discovered that it was part of the judicial process. So Paul Katami, one of the plaintiffs who had been the victim of a hate crime and who'd been pelted with stones and been physically harmed as a gay individual, said that he just didn't have the energy to do it until he realized that he would be testifying, in a witness stand within the confines of a courthouse with bailiffs and a judge to keep things in order. Fourth, the trial was human. It never forgot the human stakes of what was in play. So Ryan Kendall testified on day 5 about the immutability of sexual orientation and the trauma that he encountered when he went through conversion therapy. 2 days later, a psychologist testified using Venn diagrams and bar charts and statistical analyses about exactly the same issue. And I want to argue, along with Elaine Scarry, a literary scholar up at Harvard, that both were needed, that we need both narrative compassion and statistical compassion, that we need the individual story in order to bring the data to life. But we also need to know, if we are to make policy that binds 320 million individuals, that that story is not idiosyncratic. So I want to argue that both of these witnesses made the other's testimony stronger. And then finally, the trial was dramatic. I mean, we read everything from Brown v. Board to To Kill a Mockingbird for a reason. There's something tremendously exciting about the clash of proofs and the clash of ideas in which ultimately one side has to win out. Right? So these 5 values, right? The rigor, the comprehensiveness, right? The civility, right? The humanity, and the drama are all things that I want to convey to students when I teach them on their quest for the truth. I asked them to measure their experience in debating with their classmates, in taking their classes, and doing their readings about how well they can match these touted values of the trial, right, in achieving the outcome that they believe to be the truth. So I want you to see this book not only as a Valentine to same-sex marriage, but also a Valentine to the civil trial and the truth-finding and fact-finding processes that I still think the judicial process does best. And finally, I want your students to see that the truth matters. You know, this particular trial laid some of the groundwork for the 50-state ruling we got just this past June in the Obergefell case. And even as we celebrate that victory in the United States, there have been efforts to roll it back through various pieces of legislation, like the Religious Freedom Restoration Acts occurring in various states. And there have been prophylactic efforts, if we look globally, to making sure that the over 180 nations that do not have same-sex marriage stay that way. So the number of sodomy statutes criminalizing same-sex sexual activity has been on the rise, not on the wane, globally. So I want you to think about the fact that your students need to understand that this is not a completed issue, and that, indeed, at the global level, we are, if anything, moving backwards. And finally, I'd love to be able to convey to your students the idea that the truth matters in shaping human lives. I always say to them that when I first came out of the closet or came to terms with my own sexuality in graduate school way back in 1992, I was at Oxford, and the only consistent foray I made from my rooms to the college chapel was to pray to gods I was not sure I believed in for conversion to heterosexuality, because that was the only way I thought I could lead a good life, because I desperately wanted to get married, and I desperately wanted to have children. And for me to remember that young man knelt down in prayer is a very difficult thing for me to do, because to see him clearly is to feel the outlines of my present self grow fainter, as he so ardently wished the annihilation of the man I have become. And I want to say that part of the great arc of moral history is that that young man knelt down in prayer could never have imagined that I would be standing here today addressing this audience as somebody who is now fully married to my husband, not just for state law, but under federal law as well, that no judge in this country who marries a same-sex couple needs to temporize or to show the kind of courage that my own judge did. And that since we've gotten married, my husband and I have welcomed a daughter and now a son into that world. So it is now living the life that my young man, the young man whom I once was, thought would be unimaginable, the world in which I could marry the person I loved and to create a family. It is now that life that, to me, feels unimaginable, and this trial which allowed that life to come into being. Thank you.